My name is Aaron Greenspan. I'm the founder of Plainsight, and I thought it might be interesting to discuss a little bit about the federal lawsuit I filed in May 2020 against Elon Musk and Tesla. And I think that the cases may be a bit confusing because there's a lot going on with it, and there hasn't been a lot of media coverage about exactly what is being alleged and why. So now that it's going to be before the Ninth Circuit Court of Appeals in April, it seems like maybe some explanation could help with understanding of what's really going on. So the case was filed initially because I was the target of an internet harassment campaign that was spearheaded by one of Elon Musk's biggest fans, whose name is Omar Kazi. Mr. Kazi lives in Torrance, California, near SpaceX's headquarters, and became a fan of Tesla more or less after purchasing a Model 3 in 2018. Um, he was one of many people on the internet, and especially on Twitter, who was vociferous in support of Elon Musk's mission and Tesla's goal of accelerating the transition to sustainable energy. And there's nothing wrong with sustainable energy. I'm all for it. But Omar tended to be very critical of anyone who questioned Tesla in any way, and of journalists, of short sellers, and he was pretty vicious as an online personality, although he seems to be very nice when he wants to be in person, from what I've seen. So it's a bit of a mystery why this all even happened, but for whatever reason, Mr. Kazi decided to lead the charge against Elon's perceived enemies. And after a while, this became something that seemed like it should be legally actionable. I received a fax with some kind of pornographic image that looked like it might be child pornography, and it wasn't clear, but I then received a text message suggesting that this was part of an effort to frame me for child pornography possession, which is a federal crime and something that obviously anyone should take seriously. So after reporting that to the FBI and the San Francisco Police Department, things I thought might get better, but instead they got worse, and eventually it became the kind of thing where I thought the only real recourse was to go to court. So I filed the complaint in federal court. There are both federal and state claims, and so if you're not aware, the way that it typically works is that if you only have state claims in your lawsuit, meaning causes of action under state law, then you go to state court. But if you have both, then you go to federal court, and the federal court can exercise what's called supplemental jurisdiction, where they sort of cross the boundary between federal and state and will exercise jurisdiction over both types of claims, so that you don't have to go to two different courts for the same case. And there were actually several amended complaints filed at the district level. There was the first amended complaint a few weeks after the initial one. There was a second amended complaint once everyone had been served and it was clear what the case was about. The court actually didn't rule substantively on anything until the third amended complaint was filed. And then I was given one more opportunity to amend because it was the first time the court had looked at it. And so the most current version of the case at the district level is the fourth amended complaint, which is docket number 131. The claims in the case are, as I said, both federal and state. There's claims for libel, harassment, and then there's federal claims for copyright infringement, violations of the DMCA, and securities fraud. And the securities fraud claim is probably the most important one because it really gets to the crux of why Tesla is not the company that a lot of people think that it is. In my view, Tesla and Facebook at this point are sort of tied for the largest corporate fraud in history by market cap, because each of them has achieved a market capitalization of about 1.2 trillion with a T dollars, which is a staggering sum of money. And they both have achieved that, which, and the lawsuit gets into this, through what I call primary metric fraud, which is where you take your primary metric. In Tesla's case, it would be deliveries. And in Facebook's case, it would be DAUs or MAUs, which is daily active users or monthly active users. And you just lie about it. And it's surprisingly easy to do because if you are a big company that controls its own primary metric, there's not a lot that you can do to try to question those numbers. You have to really dig in pretty deep to get an understanding of how they could be possibly manipulated or fraudulent. So, um, the deliveries issue is one of many sort of sub issues in the securities claim in my case. And there was also, discussion of full self-driving and autopilot and robo-taxis and a lot of the false claims that Elon has made over time. Those are all sort of lumped into one big federal securities fraud claim. And obviously, I'm not the first person to accuse Tesla and Elon Musk of securities fraud. He, I think, by my calculations, which are on Plainsight, is the most frequently sued individual for securities fraud in human history. So I am one of a growing number of people who joined the club suing Elon Musk, for better or for worse. But now that this case is on appeal before the Court of Appeals for the Ninth Circuit, it presented an opportunity to address a really important issue that I didn't even know about before filing the lawsuit, but as the suit progressed, seemed to me to be more and more important. And that is the issue of the Private Securities Litigation Reform Act, or PSLRA. This is a law that was passed in 1995 by Newt Gingrich's Republican Congress. And the goal of the law is essentially to protect large corporations. It is the American oligarchs' secret weapon. And what I mean by that is it's a law that provides an almost absolute shield for corporate malfeasance, because the PSLRA seeks to limit the number of securities lawsuits that can actually get through the courts. And the reason that Congress decided that that's something they wanted to do in 1995 was because there was supposedly this problem of fake plaintiffs coming to court, having bought maybe 1 or 2 shares of stock, and then claiming that they had lost large amounts of money based on that paltry stock ownership. And once they got to court, they would then get discovery, and with discovery, you can sort of rifle through a company's files and see what's going on internally. And companies really didn't like the idea of having to deal with all of that paperwork and the headache, especially if the plaintiffs didn't really have a valid claim to start with. That's the pretext for the PSLRA. Now, did this actually happen as frequently as Newt Gingrich would have liked people to think? Probably not. But that's what got passed. And so that law has been on the books for nearly the past 30 years. And what's very interesting from my perspective is that in the past 30 years, when the PSLRA has been the law of the land, there have been 0 federal lawsuits under securities law where a pro se plaintiff was able to get their day in court. So it has become effectively impossible to sue a company for securities fraud in the United States unless you go through a class action securities firm and sue as part of a class. Now, that's something that you can do, and it's something that's fairly commonplace at this point. But even those lawyers with all this specialized knowledge of the PSLRA have a lot of trouble getting claims to get heard because the law is so stringent. So one approach on appeal would be to just argue that what was alleged in the district court was specific enough and clear enough to make it through, and that the court should reverse the dismissal because the PSLRA is too stringent. That's one approach, and that's the usual approach that most securities plaintiffs take when they go to appeal. That's actually not what I decided to do. My approach was to look at the law sort of in its entirety and decide that it's actually not a valid law in the first place. And that's because of another law that's been around a lot longer called the Rules Enabling Act. And what the Rules Enabling Act says is that when a federal statute conflicts with the federal rules of civil procedure, which are sort of jointly written by the courts, mostly by the courts, but then approved by Congress every so often, when the rules in court and federal law conflict, the rules always win. That's what the Rules Enabling Act says. And the goal there is just to make it so that the rules of court aren't constantly changing in such a way that it's so confusing you can't even figure out what's going on. I mean, that's kind of the status quo anyway, but nominally that's there to sort of protect everyone from a rogue sort of renegade court system where nothing is the same day to day. So the question is then, well, how does the PSLRA conflict with the federal rules of civil procedure? And the answer is it conflicts in several ways. And that's because the solution that its drafters came up with to help large companies get away with murder, essentially, is they decided to make it impossible for claims to survive. They imposed what's called an elevated pleading standard, where your allegations at the district court have to be extremely specific. You have to know in advance the state of mind of the executives that you're complaining about. You have to know what they were thinking, why they were thinking it, when this all happened, how they made their decisions, who was involved, everything down to the last detail. And that's as part of a requirement that's generally referred to as scienter, which is the state of mind. And then there has to be other indicia that you have a valid claim, such as loss causation and reliance and materiality. And all of these things, if they're not present, if even one of them is not present, your claim will not survive and your case will be dismissed. So the PSLRA makes it so difficult to get a claim through that it doesn't seem like it could possibly be constitutional. You don't want to have a republic in which you have laws that are so difficult to abide by that you literally can't. And so it sort of negates the point of having laws in the first place. So in my appeal, I'm challenging the validity of the PSLRA, which would have implications, obviously, for my case, where the PSLRA is involved, but also for every other securities lawsuit filed in the country. Now, if the Ninth Circuit saw things my way, which, there's probably a low probability that that will happen, but it's possible, that would then apply only within the Ninth Circuit, and that might set up an interesting circuit split kind of situation for another plaintiff to come along and take to the Supreme Court. I don't think that's going to happen in my case necessarily, but it's part of a progression that could eventually take place, whether it involves this case or another. So that's one issue that's in the lawsuit, Greenspan versus Kazi. There's another issue which involves copyright law because Mr. Kazi, as part of his internet harassment campaign, used a copyrighted photograph that normally I wouldn't have much of a problem with people using on a fair use basis. But the question is, when you're deliberately going after somebody in a really nasty kind of way, can you use a fair use defense? And that's a question that really hasn't been answered very well by precedent so far. So that's a kind of second component of the case. And then there's another issue involving judicial recusal, which has been a big deal as high as the Supreme Court recently with Justice Clarence Thomas and even the Chief Justice John Roberts. So it's more akin to the Roberts situation in my case, actually, because John Roberts, his wife, is a consultant who's highly paid, and the question is whether there should be recusal when a judge's spouse has some sort of maybe nominal involvement with the law firms in a case. And that's what happened here. The wife of Judge James Donato, who was the district court judge who heard this case, is a lawyer placement agent. She places lawyers at law firms who are looking, if lawyers are looking for jobs, then they go to her and she'll help them find a new position at a different law firm. And both of Elon Musk's and Tesla's law firms are her company's clients, and it actually just says so on their website. Moreover, she advertises on her personal page on that site that her husband is a federal district judge. It's kind of shocking, actually, that you would advertise that kind of thing to your clients who are paying you for positions at different law firms. But in any event, I think Judge Donato should have recused himself on that basis, especially because one of the firms that Elon Musk was using, Cooley LLP, is a firm where Judge Donato used to work himself. In response to my recusal motion, Judge Donato said that he didn't have any connection to that firm anymore, but that actually wasn't true because that firm is paying his wife. So, you know, I might have figured this out much earlier, except that he recused the name of his wife's employer on his financial disclosure form, and it takes about a year to get copies of those most recent forms anyhow, and the judge who authors the form gets notified when you request it. So it's a pretty laborious and not exactly impartial process to get that kind of information. But when I finally got it, I realized that it didn't seem quite right. Arguably, the biggest issue in the case, though, is the PSLRA challenge. And I don't know that that's gotten enough media attention because it's such a complex part of the law that, I mean, even for lawyers who have worked on security cases for years, it's just securities cases for years. It's extremely difficult to grapple with. And one example of the kind of detail that has come up in the appeal is that the district judge, Judge Donato, decided that he didn't think I should have the opportunity to submit more than 50 pages for a complaint. And I protested against that because it seemed unfair to me. And he said, okay, well, then maybe 75 pages. But if you look at other PSLRA complaints that have been filed in the Northern District of California, where Judge Donato sits, often these complaints are 100 pages, 200 pages. There's a table that another one of his fellow judges required in a case recently about Facebook under the PSLRA, where the table alone was over 400 pages. And so this is a law whose requirements are so onerous that it takes 400 pages of single-space type to explain what it is that you're alleging that was done wrong in a securities context. So it's the kind of thing that makes the securities bar a lot of money, because if you're charging $1,200 an hour and you've just been ordered by a judge to file a 430-page document, I mean, that could be a substantial windfall for your firm. Unfortunately, even though it may be good for law firms, it's really disastrous for democracy because this law, it does two things in order to achieve its goal. It elevates the pleading standard, making things so complex, and at the same time, it limits access to discovery until after the motion to dismiss has been resolved. But this sets up a catch-22 because in order to succeed at defeating a motion to dismiss, you need all of that detailed information. And if you can't get it through discovery, either you can't get it at all, or in some limited number of cases, you might be able to get a whistleblower to provide you internal documents that would maybe corroborate your claims, but there's no guarantee that that's going to happen. And obviously there's a lot of risks involved with whistleblowing, and that's just a very complex area of law in and of itself. So there is an allowance for that possibility that like what they call a confidential witness will step forward. But even that's not a guarantee that you'll succeed at defeating a motion to dismiss under the PSLRA. So I think there needs to be more discussion of this in mainstream media because it does affect so many people, not just people who are suing over securities law violations, but really everybody, because this is a main avenue for information to be divulged about what large companies, what publicly traded companies are doing. And it's essentially been closed off to the American public since 1995. Even lawyers fighting these cases have only gotten to trial, I think, somewhere on the order of 15 or 20 times in 30 years. So it's extremely difficult to get through the gauntlet that Newt Gingrich and his friends set up. Um, at this point, I think I was hoping to be able to sort of answer questions in real time, but unfortunately, YouTube has made that more difficult than I thought. So I'm going to just end this here, and maybe in a future video, maybe before oral argument in April, I can answer any questions that people write in the comments. Thank you.